thanks for joining us. I think you'll also enjoy meeting our speakers today. First one is Kevin Neubauer, and Kevin is a partner in the investment management group at Seward and Kissel in New York. And he works with various private investment funds, pooled investment vehicles, and the like. And also I want to introduce to you Angel Hall. Angel is an associate in the Seward and Kissel investment management group. She's here in Washington, DC. She was in New York. Of course, she's also been in Texas. So she has experience in more than one state. And some of you are all around the country, actually. So we appreciate your joining us today, and we look forward to a discussion. You may ask questions in the chat box, as Megan said, and we'll try to answer those as both time allows, and however the discussion is going, we'll try to be sensitive, not to make it as too intrusive. So the next thing I just want to, well, Kevin, why don't you say hi? And then Angel, why don't you say hi? And then we'll talk about what we're going to talk about today.
Afternoon, everybody. Thanks for having us. Looking forward to an interesting discussion.
Good afternoon, everyone. Thank you so much for joining us today.
Okay, well, thank you both. If you go to the next slide, we have our agenda, and just so you know where we're headed, and would take at least half an hour, but we've given it 45 minutes here so we can answer your questions. But we'll talk about the background of the rule, the summary of the rule, persons required to register, registration forms and filing fees, and examination requirements and waivers, implementation period, and resources. And we also will take questions as we talked about it. So New York is the last the last state to require registration of investment advisors, and probably have more than most people, but it's a fairly big job, and it's a little bit unique from that standpoint. When Wyoming was the last state to have a securities regulation law, there weren't as many people there, so I guess we didn't have a webinar on it per se, but we thank our guests for talking today. So with that, let me turn it over. I think, Kevin, you're going to start out, are you?
I think we'll start with Angel. Go ahead, Angel.
Angel will start. Thanks, Angel. Sorry about that.
No worries. To provide a little bit of background, New York recently adopted regulations imposing investment advisor registration examination requirements on certain natural persons who are associated with state registered advisors, SEC registered advisors, and solicitors. The new regulations were effective February 1st of 2021. And as Paul mentioned, prior to February 1st, New York was the only state that did not register investment advisor reps, although New York did have an exam requirement. The new regulations also provide an implementation period through December 2nd, 2021 for persons who were permissively engaged in the investment advisory business before the new rules were effective. Next slide, please. Just to give a summary of the rule, the new regulations impose registration exam requirements on investment advisor representatives conducting business in New York. New York adopted a new defined term of investment advisor rep, which includes for persons who are associated with state registered investment advisors. An investment advisor rep means a natural person who represents a state registered investment advisor in providing investment advice, a natural person who represents a state registered solicitor. And there are separately defined terms that impose registration requirements on other persons who fall under the definitions of principal and supervisor. And we'll walk through those defined terms shortly. For persons who are associated with an SEC registered advisor, an investment advisor representative means a natural person who works from a place of business located in New York and satisfies the federal definition of investment advisor rep that's provided under the Advisors Act of 1940. And we'll walk through the analysis in later slides. One thing I want to point out is that with respect to persons associated with SEC registered advisors, New York's requirements comply with the National Securities Market Improvement Act of 1996. Next slide, please. So this is just a quick snapshot of the categories of persons who are subject to investment advisor registration and examination in New York. So the first category is natural persons who work for a state registered investment advisor as an investment advisor rep, principal, or supervisor. The second category refers to principals or representatives of a solicitor. And the third category, again, refers to natural persons who both work for an SEC registered investment advisor from a place of business in New York and who satisfy the federal definition of investment advisor rep. Next slide, please. So under the new regulations, New York adopted some defined terms. The definition of investment advisor has not changed, except it excludes federally covered investment advisors, also known as SEC registered advisors, and separately defines federal covered investment advisors to be those persons who are registered with the SEC under the Investment Advisors Act. Principal is a newly defined term, and it means a natural person who directly or indirectly controls a state registered investment advisor or solicitor. So note that this requirement for principals to register will not apply to SEC registered firms. It only applies to state registered advisors. Another newly adopted term is supervisor, which means a natural person who directly supervises an investment advisor rep of a state registered advisor or supervisor. Next slide, please. An additional newly defined term is solicitor, which just refers to entities that receive compensation for introducing prospective investors or investors to a state registered investment advisor or an SEC registered investment advisor. And again, these persons are SEC registered advisors are excluded from the definition of investment advisor under New York law. Next slide, please. Here, Kevin will actually walk us through the analysis for determining whether persons associated with an SEC registered advisor need to register in New York.
Thanks, Angel.
Before we make this transition here, we've already got one question, but it's sort of a fundamental one. It says, do registered investment advisors from other states, for example, Maine or Massachusetts, who have clients in New York, have to register, update their U4 forms to do anything pertaining to this new regulation?
So there weren't any changes to if the person falls under the definition of investment advisor rep, meaning that they have more than 5 clients in New York, then they could potentially be subject to registration. This is a state registered advisor, is that correct?
Probably not. It's just whether or not somebody that works for, let's say, a firm in Massachusetts and they are talking to clients in New York, would they have to register for doing that? In other words, and I think the answer probably is that you need to be in the state that you have to register as an IAR. So it may well be that that person wouldn't have to, but let me defer to you guys.
So if they have more than 5 clients in New York, then the answer would, if those clients aren't excluded, then the answer would be yes, that they would need to register in New York. We can double check that and follow up just to make sure that there isn't a place of business requirement. But this person is not conducting any business from the state. They're just reaching out to clients who are located in New York. Is that correct?
Probably.
Okay, so I think that the answer would be yes, but we can double check and follow up on that.
And there are, as Angel mentioned, there are exclusions from clients who count for that 5 client test, and that the various exclusions vary state to state. I don't know the New York ones offhand for purposes of this test, but it would generally exclude institutional type clients, but count more retail type clients. That's the general gist of how those exclusions work.
Yeah, so it's hard to give a general answer without having more specific information.
Well, the 5 client person, I mean, has to do with whether or not you, the firm, are doing business in the state and have to notice file in the state as the firm on your form ADB, for example. And it probably wouldn't be the same as an investment advisor representative registration, but
well, the advisors, the reps clients would be deemed the firm's clients as well. So it would subject the investment advisor to potential registration in New York as well.
Right, so the firm would definitely have to notice file in the state doing business.
Or register if it's not, if it's the state register firm. That's why I was indicating we need a little bit more information, but I can just pull up the general guidance and give you the various scenarios, and we can send that out to the group afterwards. But it's very facts based and specific.
Right.
So like, for example, a rep can't register in New York if the underlying advisor is not required to register in New York. They have to be tied to an advisor who is also registered or required to notice file in the state of New York.
Right. Okay, well, we have other coming in, but let's move on to Kevin.
Great, appreciate the question. So anyway, back to what Angel was saying. So just to sort of recap, the new regulation defines investment advisor representative and requires IARs to register in certain circumstances, but it uses a different definition of investment advisor representative with respect to New York State registered investment advisors and with respect to federally covered investment advisors or SEC registered investment advisors who have a place of business in New York. And so Angel covered the rules with respect to New York State registered investment advisors, but again, for SEC registered investment advisors who have investment advisor representatives and a place of business in New York, there's a separate investment advisor representative test, and that's what's set forth on this slide. So the requirements are, the investment advisor representative must be a supervised person of the advisor. And a supervised person is the definition of supervised person under the Advisors Act. Typically, it's evaluated in the context of whether or not a particular person is subject to the advisor's compliance policies and procedures, but the technical definition means partner, officer, director, or employee, or other person who provides investment advice on behalf of the advisor and who is subject to the supervision and control of the advisor. So these would be people, basically employees, officers, owners, whatever, and then other maybe consultants or contractors who look and feel like employees. So back to the definition, investment advisor representative means a supervised person who has had more than 5 clients who are natural persons, but excluding from the 5 client natural person test are qualified clients. So again, qualified client, this is the same definition that's used under the Advisors Act to determine whether or not an advisor can charge a particular client performance fees. And the basic definition of a qualified client, as many of you probably know, is a client with 2.1 million in net worth, excluding the value of the client's primary residence, or $1 million under management with the advisor, then that person would be deemed to be a qualified client of the advisor. So for the 5 client test here, you exclude natural persons who are of the more sophisticated variety. So we're looking at more retail clients. And then the second prong of the definition, and more than 10% of the investment advisors representatives are clients who are natural persons, excluding a natural person who's a qualified client. So again, we're not concerned here with investment advisor representatives who have institutional clients. We're only looking at natural persons, and we're excluding the more sophisticated variety of natural persons. And then if we can switch to the next slide, we can just cover the other kind of federal hook here, which is, in order for a federally registered investment advisor to have this investment advisor representative registration obligation for its reps, it needs to have a place of business in New York. And so this is actually a more interesting and complicated analysis given the work from home environment all of us have been in. But the basic definition of a place of business is an office at which the advisor representative regularly provides investment advisory services, solicits, meets with, or otherwise communicates with clients, and any other location that's held out to the general public as a location which the advisor representative provides advisory services, solicits, meets with, or otherwise communicates with clients. So the second prong of the definition might be, the advisor doesn't really have an office in a state, but they say they do, and they meet with clients at a WeWork or something like that. That could theoretically be deemed to be a place of business. What I alluded to before is that given that everybody's working from home, there's a question that's raised as to whether, let's say you had a New Jersey-based investment advisor or a Connecticut-based investment advisor, and you had employees working from home who live in New York, who regularly provide investment advisory services. They likely don't meet with prospective clients at their home, but it's possible, I suppose. or otherwise communicate with clients from home, from New York, even though the advisor's real, brick and mortar office is located in, let's say, New Jersey or Connecticut or wherever. Then the question is, does that investment advisor have a place of business in New York? I think if we were evaluating this question a year ago, when, as a general matter, people work from home less, I think we very clearly say, no, let's not be ridiculous. If somebody's working from home sporadically, that doesn't mean that the advisor has a place of business in that state where they live. But now, going forward, if this work from home environment continues, and I think many people think that it will, it's an interesting question. I think that the intuitive answer is that somebody working from home in New York when the advisor is located outside of New York, that shouldn't make New York, that shouldn't make the advisor have a place of business in New York. But there isn't really any support for that under the definition. And so it'll be interesting to see how this issue plays out in the weeks and months ahead when firms develop their work from home policies on a kind of more going forward permanent basis.
Excellent point, Kevin. Let me ask a question here that's sort of a compilation of some questions that have been raised. In order to be defined as an investment advisor representative, those are the ones who has to register, you need to, as Angel said, you need to have 5 or more natural persons who are clients. Do those natural persons that are clients have to be in New York or does it matter maybe what state they're in order to be defined as an IAR? And then if you're in the state and have to register with a place of business or something, you register, or is there any requirement in New York that your 5 clients to define you as an investment advisor representative have to be in New York?
So we're referring to state registered advisors. If you're located in New York, it's going to be if you have 5 clients because you're conducting business from the state of New York. So if you have 5 New York clients who are not excluded from the definition of client, which would usually be natural persons. So if you have more than 5 clients, and you're subject to registration if you're associated with a state registered advisor, and it's based on the fact that you have more than 5 clients in the state.
Well, most of our members are SEC registered investment advisors, and some that are asking the question here are definitely not in New York. So I don't know.
Then it goes to the analysis that Kevin was just providing, where it's based on if you don't have a place of business in that state, then you would not be subject to the registration requirement. There's no place of business as defined under the federal law.
Okay. All right.
That answers the question. I'm looking at the questions in the chat, and I think that I just want to clarify the distinctions between a state registered advisor and what requirements and what issues would trigger the registration requirement for state registered advisors versus SEC registered. For SEC registered persons associated with SEC registered advisors, if you do not have a place of business in the state of New York, you're not conducting business from any location that would fall under the definition of place of business, then you would never be subject to a registration requirement in New York.
Thank you, Angel. That's definitely clarifying.
Okay, perfect. Do you want to walk through some of the other questions before we move on to a registration requirement? Because I see there's several, and I just want to make sure we cover them so that people understand exactly who the registration requirement would apply to. So I see there's a question about solicitors. Is that solicitors located in New York or solicitors that solicit New York residents? Solicit New York residents. Anyone conducting that service in the state of New York. Looks like the definition would cover them, but this is a newly defined term. New York may issue additional guidance clarifying that point. All they've issued so far is the definition.
Does the solicitor aspect have anything to do with whether or not they are an investment advisor? Let me give you an example. In California, it says an investment advisor, I'm talking about state registered ones there, says somebody who provides regular and continuous investment advisory services or solicits. Well, if you solicit then in California, you may be required to register as an investment advisor, even though you have no assets under management. Is there anything like that in the New York laws that would pull people in to be an investment advisor just because they're soliciting?
Yeah, that is my interpretation of the definition. If you're soliciting in New York, then you would be deemed, you could be subject to registration in the state of New York. It does not indicate that you have to actually be located in the state of New York.
Okay, so you might have to register as an investment advisor, state registered in New York, even though you're not triggering the requirements to register with the SEC, like with over 25 million assets under management, which, by the way, that brings up another distinction of New York, that they're the only state that it doesn't jump up to the $100 million baseline that most of the states do, because New York didn't answer affirmatively that they provide regular examinations of the advisor. So they left it at the 25 million. So you can register with the SEC on that point. So,
Paul, it's interesting you raise that. I think it is a little surprising that that continues to be the case, given that New York is the only outlier here. And I think the result of it is that, the rules that we've been discussing here that apply specifically to New York registered investment advisors, there just aren't that many of them, right? Because as a proportion, there are fewer of them in New York than there are state registered advisors in other states, although granted, there are obviously very many investment advisors in New York. Because as you point out, once you cross that $25 million threshold, you're eligible to register with the SEC, unlike in other states.
good point. Yeah, as I recall, the discussion at the time when the New York didn't want to go ahead and take the responsibility for those between 25 and 100 million, there was like 840 firms that would fit that category, and New York wasn't prepared to go examine that many more firms.
Yeah.
One of the reasons that they cited. So anyway, there is that anomaly that continues. Again, it's something distinctive about New York. Okay.
Let's see, there's another question. Does an SEC advisor based in New York only have this responsibility for its New York-based clients? I believe, if I understand the question correctly, the answer to that would be yes. They would only have to register. Well, if they're based in New York and they're SEC registered, they would have already notice filed. They should have already notice filed in New York if they're SEC registered.
Yes, if they have more than 5 clients in New York, the firm, wherever it is, would have to notice file in New York that it does business there. Yes.
Yeah. That's interesting.
We're not that we're getting onto this, but I said I might mention it because someone raised it recently with us. There's a distinction between how quickly do you have to change your registration as to notice filing in a state, because the SEC rules as to changing the requirements for answers to question 2 and 5 and some other things only have to be made once a year. Well, the state likes to get its $200 fee or whatever if you're notice filing there. And so if you wait until March 31 to say that last July we hit our 5 and we should have been paying, in New York, the states may not be happy with that. There's at least one state that we've confirmed that with, and I alert you to other states could be in that situation. So,
yeah, that's always a surprise to advisors when at the end of the year their IARD account is deducted for those state notice filings, when they expect that they'll be deducted the following March when they make their annual ADV amendment.
That's a good reminder, Kevin. You are right. Not only that, but it's a little complicated around in late December because FINRA runs the IARD for the SEC. It's the SEC's program, but it all shuts down for a week so they can run updates and stuff like that at the end of the year. And you need to have the money in the account before that so that you don't overdraw your account, so to speak. Right. So keep track of what you got, and we'll get to it later, or good time to remind it here. But on our website for our members, we have charts on what the requirements are and the costs are in each state, so you can plan ahead.
I'm just scrolling through the questions because some of these were answers or exchanges between some of the members. So question here, federal registered advisor, notice filing more than 5 clients in New York, but has no place of business in New York. Are IRAs servicing New York clients? Do they have to file? Well, if the representative does not have a place of business located in New York, according to the statute, that representative would not be required to register in New York because there's no place of business located in New York. And let's see, some of these have already been answered, so apologies. I'm just trying to make sure that we cover everything without repeating information. What if you are an SEC registered advisor and you're located in New York? If you have junior advisors who technically don't have clients yet, but they do solicit clients, would we need to register them as an investment advisor rep or a solicitor? So the solicitor registration is registering them as an investment advisor rep. It's the same form, same process. So it sounds like they would need to register as an investment advisor rep if they're soliciting if they're conducting solicitation activities as defined under the statute.
So that might be a little different for New York than a lot of states, because if they didn't have the clients, then they might not fit the definition of an investment advisor representative in most states, which is the main thing that's usually registered. Because here, like you said, you specifically have to register if you are a solicitor of it, right? Regardless of whether you're an investment advisor representative as defined.
Yes, the definition of investment advisor rep includes persons who are acting as solicitors. So, but then there's a separate definition for solicitor. So it's a bit confusing.
Good point. Well, we're glad we have you here to clarify it for us, Angel. We all
As much as we can, because again, this is a new area. They're still releasing additional guidance to clarify the regulations that they adopted.
Good point. Good point. And you're not past the deadline yet. You still got time.
Exactly. Still plenty of time. Solicitors, if an individual must register as an investment advisor rep, does their employer have to register as? Yes, because there's an FAQ where it indicates that you must make sure that the person must make sure that their associated firm or advisor or solicitor firm is first registered or notice filed before they can file the form U4. So the answer to that question would be yes. Okay, there's clarifications to some questions I asked. Let's see. To clarify, it means investment advisor reps for SEC registered advisors who have clients in multiple states have the registration requirement only with respect to their New York-based clients. I'm not sure I understand the question.
I think that might be a derivation of what I was asking before, is if you are in another state and you have 5 or more clients that make you an investment advisor representative, but all those clients aren't in New York, do you have to file in New York just because you have, let's say, 1 client there? I think that's where it would come into play, whether or not you are actually in New York, whether or not you have an office there.
Exactly.
So the answer then, it would be then if you have an office, notwithstanding the fact that those clients are outside of New York, you would still have the investment advisor representative filing obligation.
Yeah, if they're going to be soliciting in New York and you have an office there, and it sounds like, if I'm reading what Angel's saying correctly, that they may well have to register as an IAR in New York.
Correct. Sorry. Gail Bernstein, I'm not sure if I understand you. You're asking for clarification on whether something's a New York or SEC definition, and if you could send another clarification, because I'm not sure which definition you're referring to. So I'll wait for Gail to clarify, and we can move on to the next slide if there aren't any additional questions on this topic. Okay, so once it's been determined that registration is required for a representative, that person would need to file a Form U4 electronically through CRD, pay a $200 filing fee, and make the amendment filings in accordance with the Form U4 instructions, and there are also annual renewal requirements. Next slide. Okay, so examination requirements. So persons who are required to register as an investment advisor rep in New York, they must either receive a passing score on either the Series 65 exam or both the Series 7 and Series 66 exams within the past 2 years of applying for registration as an investment advisor rep, or obtain a waiver from the examination requirement. And we'll discuss the waivers in the next slide. One thing I wanted to note is that the New York's examination requirement is not new. All principals, supervisors, and investment advisor reps of advisors who were registered with New York prior to February 1st, 2021 should have already satisfied the pre-existing exam requirements or obtained a waiver. And prior to February, the compliance was previously documented by filing a form NYIAQ with New York. I think there's some more questions. Let's see what we have here. Okay, so Gail saying, I think you said that the solicitors would need to register, but if they work for an SEC IAR, I assume you mean registered advisor, wouldn't the federal definition of IR? Yes, the solicitor registration requirement applies to state registered advisors. So sorry if that wasn't clear. There's no, if a person is associated with an SEC registered advisor, then there's the solicitation definition under New York law does not apply to them. First, anyone who's associated with an SEC registered advisor only needs to worry about the federal definition of investment advisor representative. That is the definition that will determine, that definition together with the place of business definition is what determines whether that person needs to register in New York at all.
Right. And again, that IAR definition for federal registered advisors is a supervised person of an advisor who has more than 5 clients who are natural persons, excluding qualified clients, and more than 10% of those clients are natural persons, again, excluding a natural person who's a qualified client.
Good points, yes.
Okay, I think that's.
Thank you for clarifying those. The interplay between them is interesting.
Yeah, I just wanted to be clear, the solicitor definition has no bearing on any registration requirements for a person associated with a SEC registered firm. So sorry if that wasn't clear earlier, and I misspoke when answering some of the questions about solicitors. Next slide, please. Okay, so some persons may qualify for a waiver from the exam requirement, and there's generally 3 categories. The first category is a person who has prior registration, and that's a person who is currently and for the past 2 years have been continuously registered as an investment advisor rep in another U.S. jurisdiction. Now, this person cannot have had a lapse in their registration that exceeds 2 years. They cannot currently, and they could not have in the past 10 years, been subject to any action or proceeding that will require disclosure on the form U4 of any disciplinary actions, arbitrations, anything of that nature. The second category of waivers are for certifications. That would be people who currently hold one of the following professional designations in good standing, which are certified financial planner, chartered financial consultant, personal financial specialist, chartered financial analyst, and chartered investment counselor. Next slide, please. The third category is a new special waiver category that was adopted under the new regulations. So this waiver is available to people who are currently permissibly serving as an investment advisor rep, principal, or supervisor. And the use of the word permissibly is important because it means that this waiver is not available to persons who should have taken the exam or obtained a waiver prior to the adoption of the new rule because they were already associated with a advisor who is required to register in the state of New York. So this waiver is available to people who are currently permissibly serving as an investment advisor rep or supervisor or principal, have 2 years of prior experience in this capacity, and these 2 years are experience prior to February 1st of 2021. And these persons can, this waiver is not available to anyone who within the past 4 years ceased performing investment advisory services for 2 or more continuous years. I know that's like a mouthful. Persons who have only acted as solicitors, as that term is defined under New York law. Persons who have any disciplinary history, and it's not available for someone who does not file their application for registration after August 31st, 2021. Let's see if there are any questions on this before we move.
Let me mention one complication that I know some people have told me about in the area. You've got Connecticut and New Jersey and Massachusetts and other states around New York. And sometimes people have had registrations in other states, but then other times, because they were in New York, they didn't have registration. So maybe they had it before they moved to New York, but it sort of lapses, and they're concerned about whether or not they can go back in, or do they, if it's been over 2 years and it's lapsed in New York. Well, they've never had it in New York, but the registration may have lapsed for the Series 65, let's say, if they didn't continue to keep it up or weren't at a place that carried it. Will they have any dispensations or ways to get around there, or might they just have to take the Series 65 again if they find that it applies to them?
They might have to take it again. In addition, New York does have, I guess, what we consider a fourth potential waiver, which is you could submit a letter or some information to the Department of Law asking whether your particular circumstances can qualify for a waiver from the exam requirement.
Yeah, thanks for sharing that, because I know in some states that can be helpful to people when they're otherwise in a bind, they can't get, or they don't think they can get through. There's one question here about the 10%. In other words, five clients who are natural persons, 10% of whom are individuals. And the question is that 10% of the number of clients, not AUM of clients, correct? And the answer on that, I'm sure it must be true. Yes, because a lot of times your institutional clients could be huge and they wouldn't count at all in that category. But yeah, do you guys have any? I should be just asking you. Is that what you think?
I agree with you, Paul.
Okay. Didn't mean to go out on a limb by myself without support, either of you. Then there's another question said, basically this waiver is for IARs of a federally registered RIA with a physical presence in New York again, correct? I think we have said that, but.
Yes, that's correct. It would also, correct. The short answer is yes.
Yeah, okay. We did cover that, but people want to hear that.
On time, so. Okay, can we have the next slide, please? Okay, the next slide is with respect to the implementation period. So for persons who were serving continuously and permissibly as an investment advisor, rep, principal, supervisor, or solicitor in New York prior to February 1st, 2021, they may continue to provide investment advice without approved registration until December 2nd, 2021. Now, in order to for this implementation period to be available to them, they must submit the application for registration by August 31st of this year. This implementation period could be limited for someone who submits the application and they receive notification that there's some deficiencies and they fail to correct those deficiencies within 14 days. So if you do submit the application, you're notified of deficiencies, be sure to correct them as soon as possible, definitely within the 14 days, or you may lose the ability to rely on the implementation period. Also, New York encourages all of the potential applicants to submit everything as soon as possible because they anticipate a longer than usual review period during the implementation period. So you want to make sure that you have everything approved and that you've taken the exam if required or obtained the waiver, before the actual deadline. Doesn't look like there are any questions on this. Next.
Oh, we have one here that I'm going to have to read it because it's a statement and we can't validate for it. But if I were in this situation, I would find it very valuable to hear. So let me just read it as it's been presented here. It says, just to share my experience, the state is also requesting a letter on firm letterhead that details the work of the IAR is doing with clients. They want specific details on number of clients, investment committee involvement, et cetera. New York is not just accepting the IASW form. It's also taking over a month to get the state to approve anyone. Well, that's interesting feedback. Thank you for sharing that. We can't cross-examine you on it, but thank you for sharing it. So
There's actually, if we move to the next slide, I think that, yeah, there's the resources page. So if you were to click the guidance on mandatory registration, I guess it's the fourth bullet, that actually provides instructions on how to obtain waivers or confirm that the registration or the exams were taken, or that the waivers were obtained for persons who were previously who were already subject to the exam requirement. And it walks you through the exactly what you need to do, like sending an email. It's the same as what that person just explained. I'm sure once you actually start that process, you receive more comments, but it tells you what to do to obtain the waiver, confirm that you previously filed the form that was required before the new rules were adopted with respect to the exam requirements and all that stuff. So that guidance on mandatory registration is dated February 8th, 2021. That takes you directly to the link where the state is outlining, what actions you should take to confirm that your existing persons are have met the prior exam requirements.
I think that's very helpful. And Angel, I know I told you personally before we got started, I thought this set of resources you put here is very helpful. And I did want to call attention, the one that we added there at the end is that the Investment Advisor Association Resource Library, for those of you who are members of the IAA, might require a sign-in ability, but there we have charts on all the 50 states, both notice filing charts and state notice IAR charts. So you can see what the fees are, and it's linked to the state website, so you can interface with the website as well. So just want to make sure you know that those resources are available for most of you. So.
Okay, so it looks like we've come to the end of the webinar. Paul, if you want to let everyone know how they could, get in contact with us if they have additional questions.
Yes, thank you. Well, first of all, let me take this time to thank you, Angel, and you, Kevin, for an excellent presentation. You've answered a bunch of questions, and I am glad that we carried them as we went along, because if we had to do them all at one shotgun blast here, I think it would be a challenge for us, but I think you handled them great. But with that, let's go to the next slide. The reason I want to say that is because if you want to take notes, if you didn't get a copy of your of these slides, which I think they might have been sent to you earlier today. But anyway, the next slide, please. The last slide, please. At least mine isn't showing it. There's questions and answers, and the next one, this one. Oh no, it just shows me. But anyway, it says contact information. The email addresses are there for Kevin Neubauer and Angel Hall and myself. We'd be happy to forward any questions that you send in case you didn't get an answer to it. Just remind us and we'll try to follow through. We think we've answered all the questions. And so with that, Angel and Kevin, do you each have a final remark or something you want to say before we bring this in right exactly on time here, basically? So.
I just hope that everyone found the information helpful and informative, and definitely reach out if you need more clarification on exactly what terms apply to what state registered versus SEC registered advisors. Definitely feel free to reach out. I know it's confusing. New York adopted a definition of investment advisor rep, and then all these sub definitions that also subject certain persons who fall under that definition to investment advisor representative registration and exam requirements. So I know it can be a little bit confusing to try to tie it all together. But
I would just say, thank you to Angel for being all over this, and thank you to IAA for putting this together and hosting this webinar. And thank you most of all to the audience, because these were some great questions, and I don't think that I can recall ever participating in a webinar where there were this many detailed and engaged questions. So kudos.
Well, you guys brought out the right information for people to ask intelligent questions. So that was all very helpful. And we're getting some, not that you have to give them to us, but I'm seeing excellent reviews here at the end. So I know we have some happy clients, so to speak, members, whatever the right word is for people who've tuned in, but I just want to thank everyone for participating. Thank you, Angel and Kevin, for an excellent presentation. It was totally engaging and very helpful. So thank you all.